Yes, Mr. Todd.
Lords, my lady, I was going to take you to the decision of Mr. Justice Wright in Liggett. This was one of the authorities which my friend relies on as being inconsistent with Akai. It is one of those which wasn't referred to actually in Akai. It's a decision of, it's in Bundle 8, it's tab 24.
Page?
I'm sorry, 2611. If I may take the facts from the head note. Defendants negligently and contrary to instructions paid cheques of their customers, the plaintiff company, which had been signed by one director only, that was Mr. Liggett. The cheques were drawn in favour of trade creditors of the company and payment for goods supplied to the company in their business, and in an action by the company for money hadn't received. As the liabilities of the company had not been increased by reason of the payment, the cheques, the defendants were protected from liability on equitable grounds. And were entitled to stand in the place of the creditors whom they paid. Where bankers have been put on upon inquiry with regard to the appointment of a new director, that's Mrs. Liggett, and are guilty of negligence in not investigating the position, they are not entitled to assume that a notice of appointment of an additional director is a valid notice, that the director and that the director was duly appointed. What actually happened in this case, you'll see this from the statement of facts, and it says it's taken from the judgment of the learned judge. If I may just summarise briefly the facts. The articles provided the board needed to be not less than 2 nor more than 3 directors. The quorum was 2. The 3 cheques were paid. One of the directors was a Mr. Melia M. And Mr. Melia wrote to the bank saying, don't pay any cheques unless I've countersigned them. 3 cheques were paid by the bank on the signature of Mr. Liggett alone. And they were clearly paid without authority or any pretence of authority. And then the bank subsequently got Mrs. Liggett to countersign, but she wasn't, when she countersigned, a director. And there were some other cheques drawn and paid on one signature, that is a Mr. Liggett. And then they also were subsequently signed by Mrs. Liggett, but again before she was a director. So clearly a case involving a highly unusual transaction. The bank had been told by the other director, Mr. Melia, don't pay unless I've countersigned. But the bank disregarded that instruction. At page 2618, and yes, bottom of the page at 2618. The judgment starts at the top of that page, so you'll get those facts that I've just outlined from that statement there in the first paragraph. So I'm picking up about 6 lines up from the bottom of the page. The plaintiff's claim as for money hadn't received, that they're entitled to have repaid to them the amount of those cheques, on the ground that the defendant bank had no authority to pay the cheques. That is the issue. The primary defence set up by the defendant bank is one based upon the application of the well-known rule, which is often referred to as the rule in the Royal British Bank and Turquand, a rule which has been applied in a great many cases, and they're there referred to. The rule, after those cases, the rule is relied on by the defendant bank is that the defendant bank, having had the Articles of Association, were entitled to assume that the notice of September the 1st, 1925, sent to them by the chairman was a valid and proper notice because, according to the Articles of Association, it was possible, if the proper steps in the matter of internal management had been taken by the directors of the company, that Mrs. Liggett should have been duly appointed an additional director, as the notice stated. I'm relieved from any examination of the exact definition of this very respectable but perhaps somewhat ambiguous rule of law, because the plaintiff company, in answer to that contention, have alleged that the defendant bank, in any case, is not entitled to the benefit of that rule by reason of the fact that the defendant bank were put on inquiry by the circumstances of the case and were negligent in not investigating the position. And then he says, on that issue, I put 2 questions to the jury. Whether the appointment, was the bank put on inquiry whether the appointment of Mrs. Liggett was in order? Yes, said the jury. And then he sets the second question, to which they answered affirmatively. Whatever may be the exact scope of the rule in Turquin's case, I think it's quite clear on principle and on the authority I've already referred to, it can never be relied upon by a person who is put on inquiry. The rule proceeds on a presumption that certain acts have been regularly done. And if the circumstances are such that the person claiming the benefit of the rule is really put on inquiry, there are circumstances which debar that person from relying on the prima facie presumption that it is clear. I think that he cannot claim the benefit of the rule, and if, therefore, the answers of the jury to the questions which I put to them stand, it's clear, I think, that this defence will not avail the defendants. He then, may I pick it up then in the second paragraph halfway down, where he says that the beginning of the line is are arrived at, and picking up the next sentence, the substantial ground on which the jury must have held, and I think have properly held, that the defendant bank was put on inquiry was this, that Mr. Melia was known to them to be a shareholder and a director of the company, and was known to be very anxious that no cheque should be paid without his signature. He had given special direction to that effect, taken steps to ensure the signature should be obtained if it was not originally on the cheques, by arranging the bank could communicate with them. I think under those circumstances, the defendant bank ought, before they acted upon an instruction, such as that containing the letter, to have communicated with Mr. Melia and ascertained if his concurrence had been obtained to that change. And so that's really the essence of Liggett. The bank knew that they shouldn't be paying cheques, save with the counter-signature of Mr. Melia, yet they went ahead and did so. It's a case of actual knowledge of the irregularity, and it was a case on Turquin, and it is not inconsistent with Akai. The third case on which my friend relies is Houghton. We've looked at that, and I don't. Perhaps I can just take you to. I'm going back to bundle 7, if I may. It's tab 12, sorry, it's not tab 12 at all. It's tab 10, and. You're just picking up at the head note, if I may.
I beg your pardon, which page?
I beg your pardon. It starts at page 2109, and I'm looking at the holding, if I may, on page 2110. Held that whether the agreement was to be treated as having been made by M, L as an ordinary director of the company, or by the secretary as agent, or by the two combined, the plaintiffs were not entitled to assume that any authority to make it had been delegated to them by the board, and for the following reasons. Although a person who contracts an individual director or servant of a company, knowing that the board of directors has power to delegate its authority to such an individual, may under certain circumstances assume that that power of delegation has been exercised, and that he may safely deal with the individual in question as representing the company. He cannot rely on the supposed exercise of such power if he did not know of the existence of the power at the time that he made the contract. And secondly, there was something so unusual in an agreement to apply the money of one company in payment of the debt of another that the plaintiffs were put on inquiry to ascertain whether the person or persons making the contract had any authority, in fact, to make it. So those are really the 2 points. A highly unusual transaction, and therefore you don't even meet condition 1 of those conditions in Freeman and Lockyer. And secondly, you can't say you're relying on a power of delegation if you didn't actually know there was a power of delegation, and that's really what that's what Houghton stands for. So, I mean, for my lords and my ladies' note, Lord Justice Banks' judgment is at 2122, 2122, to 3. And it's just picking it up, if I may, at 2122, the final paragraph, the plaintiff's second ground of claim and the defence of the counterclaim were rested upon the rule of law laid down in Mahoney and East Holyford Mining and other similar cases. Upon this part of the case, the learned judge decided in the plaintiff's favour. I should not have been at all sorry if I could have shared the learned judge's view. In my opinion, the facts are too strong to admit of the application of the rule referred to. The rule and the application of the rule were recently discussed in Underwood, where the authorities are collected. Those authorities, I think, make it clear, in order to establish a case which falls within the rule, it is essential that the person who claims the benefit of it must, A, prove that he relied upon the ostensible authority which he sets up, and B, must not have been put upon inquiry as to whether the transaction was in order. He says at the bottom of the page, if I may take you to 4 lines up from the bottom of the page, 5 lines up, other passages in the evidence might be referred to, but I've quoted sufficient to show that Mr. Dart, in dealing with the defendant company, was not relying upon any ostensible authority in Mr. Morris Lowe. So not a case of ostensible authority at all. And then over the page at 2124, first full paragraph, i.e. 4 lines down. So I've mentioned the second point, I'll deal with that. Here again, I'm afraid that the facts and the inference from the facts are destructive of the plaintiff's case. In the first place, I think that the nature of the transaction was such as to put Mr. Dart on inquiry. Cannot be considered as an ordinary transaction where the money of one company is used to pay the debts of another. And then perhaps at the bottom of the page at 2124, under these circumstances, I find myself with respect to the learned judge who tried this action, unable to agree with him in the conclusion that the plaintiffs were entitled to deal with Mr. Morris Lowe, to use the judge's words, as a representative and plenipotentiary of the defendant company. I come to my decision upon the grounds which I have stated, namely that although Mr. Dart may have been entitled to deal with Mr. Morris Lowe as the accredited representative of the defendant company to negotiate the business, on his own showing, he did not regard him as a person having authority to make a contract binding on the defendant company. And further, that even if this is not a true inference from the facts, yet the circumstances were such that Mr. Dart was obviously put on inquiry to the extent of any authority that Mr. Morris Lowe possessed. So that's Lord Justice Banks. And Lord Justice Sargent at 2129, he refers right in the middle of the page, so towards the end of the first full paragraph, to the fact that there was no knowledge on the part of the plaintiffs of the power of delegation. He says, but it is quite another thing to say that the plaintiffs are entitled now to rely on the supposed exercise of a power which was never in fact exercised, and of the existence of which they were in ignorance at the date when they contracted. And then Lord Justice Sargent, that's it. And then 2130, he deals with cases which are of an unusual character. Yeah. So, my lords and my lady, what we say is that that case, Houghton, is not inconsistent with Akai. The fourth case relied upon as to the state of knowledge which undermines the state of knowledge which is requisite to undermine a finding of apparent authority. And so the fourth case relied on by my friend is Morris and Canson. Well, I've dealt with that already. We've seen that. The fifth case is Rolled Steel Products. So far, we're halfway through, and we haven't found an inconsistent case with, I'm bound to say, with Akai. The fifth case is Rolled Steel Products, and we have been to that. And during the course of that, my Lord Reid referred to what Lord Justice Slade was saying. What's this? And Rolled Steel Products is going back to bundle 8. It's at tab 27. And at page 2687, And the statement from Lord Justice Slade, yes, I'm sorry. Well, excuse me, would you just bear with me?
Yes. Well, the point, the passage which Lord Neuberger put a question mark against is at the foot of page 2736, I think. It's numbered paragraph 6.
That's correct. He deals with that in paragraph 60.
And it's where the words ostensible authority are used and ordinary principles of agency. Whereas the earlier passage that we looked at before on page 2725
yes.
Was dealing with the Rulin Turquin's case, which, as we saw, was based on a presumption as to the facts,
yes,
rather than any doctrine of agency.
Absolutely, and of course, what my Lord remembers the point, and the way that Lord Neuberger put it in Akai, which is in Bundle 7, he explains, or he gives his understanding, and Akai is in Bundle 7 at tab 12. The relevant page is at 2164. This is where Lord Neuberger deals with rolled steel. He says this, just if I may remind you, and perhaps myself, other cases relied on by the bank were simply concerned, or which simply concern the indoor management rule, including Morrison, Canson and rolled steel. It is fair to say that some of the observations in rolled steel, especially at page 296, proposition 6. And that is at 2736 of the bundle, of bundle 8, tab 27. 2736 is the bit that Lord Neuberger is referring to. If it says it's proposition 6, you see at the bottom of the page, where Lord Justice Slade says, if, however, a person dealing with a company is on notice, the directors are exercising the relevant power for purposes other than the purposes of the company, he cannot rely on the ostensible authority of the directors and on ordinary principles of agency, cannot hold the company to the transaction. So that's which Lord Neuberger was making reference in Akai, going back to Bundle 7, tab 12 at page 2164. So picking it up just above letter E at page 2164, Bundle 7, tab 12. Lord Neuberger says it's fair to say some of the observations in rolled steel, especially at proposition 6, which I just read to you, can be read as supporting Akai's case, i.e. it's lesser than actual knowledge, it would suggest. However, it seems to me, that the precise nature of the state of mind or knowledge of the person alleging apparent authority was not an issue in that case. And with all respect to Lord Justice Slade, the cases he had cited did not support the proposition. And in our submission, Lord Neuberger is absolutely correct. The precise state of knowledge was not an issue in that case. What Lord Justice Slade was doing was setting out his conclusions from the authorities on these questions of principle, and he gave summaries of those. He says which principle may be summarised as follows. So, certainly the precise issue as to the state of knowledge was not an issue in rolled steel. So that's rolled steel. So I'm on to my sixth case. Sorry, Mr. Howard's sixth case is Armagas and Mundagas, and that is in Bundle 7, tab 4. at 1963. This was a case which was referred to in Akai. It was referred to in Akai at paragraph 67 and 68. Which is at if I pick it up at 2165. And what Lord Newburger says at bundle 7, tab 12, page 2165, in paragraph 67 of Armagas and Mundagas. We have referred to 3 English cases on this topic. One of those is the Ocean Frost, Armagas and Mundagas. And he then deals with those. Let me see, where does he pick it up? Sorry, where is it? It's here. And he says at 68, the effect of these decisions appears to be that at least in the courts of England and Wales, it's very unlikely the third party could establish a parental authority on the part of an alleged agent by relying on the agent's own unauthorised statement to clothe the agent with authority. The judgment of Lord Justice Gough and the speech of Lord Keith of Kinkell in Armagas indicate great scepticism as to the notion that an agent could clothe himself with authority in this way, having said, and he gives the reference, that there might be very rare and unusual circumstances in which this might happen. And then he says how Lord Keith continued at 779D to G. So it was considered by, so Armagas and Mundagas was not in our respectful submission. Armagas and Mundagas is not a case which is inconsistent with Akai. It was a case of actual knowledge. It was actually a case of the agent holding himself out as well. It was an unusual transaction. And if I could invite my lords and ladies' attention, in the judgment in Armagas and Mundagas 2023, in the speech of Lord Keith. Perhaps I can pick it up at the bottom of 2022, letter H first, just to contextualise where I'm going. Upon the issue of Mr. Magelson's authority to conclude the 3-year charter party on behalf of Mundagas, Counsel for Armagas accepted that he did not have actual or ostensible general authority to enter into contracts of such an onerous character, but argued that he had ostensible specific authority to enter into this particular contract. Ostensible authority comes about where the principal, by words or conduct, represents to the agent that the agent has the requisite actual authority and the party dealing with the agent has entered into a contract with him in reliance on that representation. The principal in these circumstances is stopped from denying that actual authority existed. In the commonly encountered case, the ostensible authority is general in character, arising when the principal has placed the agent in a position which in the outside world is generally regarded as carrying authority to enter into transactions of the kind in question. That's why I referred briefly to the usual authority. Ostensible general authority may also arise where the agent has had a course of dealing with a particular contractor, and the principal has acquiesced in the course of dealing and honoured transactions arising out of it. Ostensible general authority can, however, never arise where the contractor knows that the agent's authority is limited, so as to exclude entering into the transaction of the type in question, so cannot have relied on any contrary representation. And what we say is that that statement that ostensible authority is defeated by actual knowledge is entirely consistent with Akai. It is a House of Lords case. It is not one of those cases which is said to be or may be said to be inconsistent with Akai. There was no discussion in that case about being put on inquiry at all. So what we say is there's no inconsistency with Akai. Criterion is the 7th of Mr. Howard's 8 cases. We've already dealt with Criterion, and I don't propose to come back to that. And the final one is a decision, and this is the second of those which was not referred to in Akai, and that is Wrexham. This is the 8th of the cases upon which Mr. Howard relies. And for this case, we need to go to bundle 9 and to tab 29 at page 2763. And this was an application for summary judgment again. A decision of Sir Igor Judge, Lord Justice Dighton and Sir Peter Gibson. And the facts, if I may briefly say what they are, is really a breach of fiduciary duty case. P, the plaintiff club, acquired a freehold with funds from the defendant, which was called the company. H owned that company, and he acquired a majority interest in the club through G. W was the director of the company, as was the defendant. So I'm sorry. I'm not going to. Sorry. Can I? That is clearly not. Can I take you to the head notes? My note is misstated. Can I say the claimant football club leased a valuable 7.6-acre site to the edge of Wrexham town centre on a long lease at a peppercorn rent. The land was used as the club's ground. In 2002, H, who was the sole shareholder and director of the defendant company, that's a crucial move, purchased a 78% shareholding in the club through an intermediary, G, who became the effective chairman and executive director of the club, although not appointed as such. In April, H and G entered into a joint venture agreement to manage and control the club with the sole objective of realising the maximum potential gain from the club's property assets for themselves. Not quite so interested, it seems, in football. In May, they persuaded the freeholder of the ground to sell the freehold to the club for £300,000. Purchase price was provided by the defendant company, crucial move. On the 25th of June, the club, acting by G, who had by then been formally appointed a director and chairman and the secretary, executed a declaration of trust acknowledging that the freehold had been transferred to the club, that the purchase price was paid by the company, and declaring that the club held the freehold as trustee for the company. In July, the club, again acting by G and the secretary, transferred the freehold to the company. In June 2003, the club surrendered its lease in consideration of the company paying its tax liability, £300,000, entered into a new lease which contained a break clause exercisable by the company as landlord on giving 12 months' notice. July 2004, the company duly gave notice of termination of the lease, and in December of that year, the club went into administration. The club, acting at the instigation of the administrators, brought an action against the company, seeking inter alia a declaration that the company held the freehold of the ground on trust for the club and applied for summary judgment on that issue. The judge, relying on evidence put in by or on behalf of H in the proceedings and in separate proceedings, brought to enforce their joint venture agreement, held that G's contractual obligation to H to manage and control the club with the sole objective of realising its property assets for the benefit of themselves is fiduciary duty, not to profit from its position, gave rise to an obvious conflict of interest. The G, in executing the declaration of trust, in the absence of full disclosure, had acted in breach of his fiduciary duty, and that regardless of whether the burden to show good faith or lack of it was on H or the club, H had indisputably not acted in good faith in relation to the declaration of trust, since the whole object of the involvement of himself and G in the club was to promote the redevelopment of the ground for their personal advantage. They had entered into a joint venture for that purpose. The declaration of trust and transfer of the ground by the club to the company were the final steps in the scheme. The declaration of trust and transfer was signed on behalf of the club without board resolutions authorising any step in the transaction, or the club having independent legal advice. The judge granted the club a declaration that the freehold was held by the company on trust for the club. The company appeal containing that the judge ought to have decided there was a lack of good faith on the part of H, and in any event ought not to have done so without a trial in view of the seriousness of the allegation. And some further submissions were made, and then held that although it was unusual for the court to make a finding adverse to the integrity of one of the parties without a trial, there's no rule preventing such a finding being reached on a summary judgment application. The evidence derived from the matters which were common ground or which had been adduced by H himself showed he had not acted in good faith. Any person in H's position acting in good faith would have been bound to inquire whether the transaction had been authorised or approved by the club or its board, and if so, whether full disclosure had been made by G. The very nature of the transaction and H's special relationship with the company meant that it was put on inquiry, and in the absence of such inquiries, the company could not satisfy the requirements of good faith. My Lords...
Where's all this going? I mean, we seem to be spending an awful lot of time on a case on rather special facts.
That's
one
what
of the cases which is said to be inconsistent, but
yes,
it's not binding on us, so what?
No,
I'm not trying to discourage you if there's something in it which is going to be helpful. But
my Lord, what we're saying is it is not inconsistent with Akai.
But I mean, so what? You know, there's some very strong criticisms of Lord Newberger's statements by Mr. Peter Watts, both in Bousted and in the articles. And if we were going to need to differ from what he said, then we'd have to look at all that quite seriously. But
yes.
Are we actually going to have to...
I am not going to take my lords and my lady through that academic criticism. I don't know whether Mr. Howard is intending to do so. It's not in my case, it's in Mr. Howard.
But is it what is the case, what is the point you derive from Akai, which isn't
that if you
established part of the...
of the law. Relevant. What it is this, that when a person is held out as having authority, apparent authority, hence apparent authority, that is only defeated if the third party to whom that person is held out has actual knowledge of
he doesn't even have to act reasonably.
Sorry?
He doesn't even have to act reasonably.
There's actual knowledge, or as my Lord Sales pointed out, or had reason to believe, that it, but certainly not as low as put on inquiry. So what I said to my Lord Sales earlier today...
Does it have to be reasonable to rely on the understanding? But I mean, what the criticism of Lord Newberger appears to be that he substituted a test to be rationality.
Yes, that's right, and that's what I say. That is what I say the test is. It is the test, as in Akai.
Do we need to go that far? Because I must say, for my part, I would be slightly concerned at substituting a test to be rationality for what seems to be much more...
Absolutely. But the way it was put, my Lord remembers the way it's put at paragraph 49 in Akai, at bundle 7, 2161, and that's what I say. What I say consistently with Akai, as found at paragraph 51 at 2162, is that it's misassumptions test which is a correct test, unless the bank had actual knowledge of the lack of authority, or its belief that Mr. Ting or that the belief that Mr. Ting had authority was dishonest or irrational, then the bank's state of mind will suffice.
Well, that seems
That's
the
it.
way
That's it.
Mr. Sumption put it, and he's been very persuasive.
I was persuaded by it, certainly, and I hope your lordships were. I was certainly persuaded. I thought it was very good.
Yes, right. Anyway, so but I mean, what I'm trying to get at is,
what am I trying
we've
to
only
get?
got another 25 minutes, as I understand it, and I'm just wondering what is the point which we're trying to get at.
That the authorities relied upon by Mr. Because Mr. Howard says, if necessary, he will say that Akai was wrongly decided, was inconsistent. Sorry, he said it was inconsistent with 8 previous authorities, including 2 House of Lords decisions.
We're dealing with the law of Bermuda here, aren't we?
I agree with it. We are dealing with the law of Bermuda. I say that Akai is correct and it is the approach which the law of Bermuda will adopt or does adopt. And I'm just simply pointing out that Mr. Howard cannot rely on these 8 cases to show some alleged inconsistency or some left turn being taken by the law when Lord Neuberger got hold of it in Hong Kong. But in fact, it was entirely consistent with the previous authority. That's the sole point, Lord. And I was just trying to demonstrate that to you as quickly as I possibly could. So I'm going to move on. I'm going to move on to my 4th point, if I may, of my roadmap, whether PT Satria was in fact put on inquiry so as to avoid the sale. And I've been through this part. Firstly, it is an investigation of what the articles would tell us about the authority of the directors. And we've been through that this morning. That is, what would they have seen in the bylaws of EACL? And I've been through that. I don't want to go through that again unless you really want me to. I'm happy to, but I don't just take up my time. And that's really what we say. We say that they were not put on inquiry by dealing with Mr. Jones and saying Mr. Harter was assenting to this transaction. They were not put on inquiry as to any want, even if that's the relevant test. Even if it's a relevant test, which we don't think it is. The first thing is, did they know? Did they have actual knowledge of a want of authority? That's the first thing, and no, they didn't. If the test is something less than not actual knowledge of want of authority, well, such as being
surely
put on
you need a holding out first.
Yes,
you don't start with.
No, and I started on. My Lord's absolutely right, and I dealt with that right at the beginning of my submissions this morning.
Yes, thank you.
You're quite right. So in relation to put on inquiry, and I dealt with that. We've been through the bylaws, and we did that this morning as to what Mr. Sardono would have known. The other point, which is said to require us to make, or the other point which is said to undermine our entitlement to rely on the ostensible authority of Mr. Jones, is that the transaction was of an unusual nature. And because it was a sale of the whole of the issued share capital of BEL, the only asset of the ACL. And so I'm going to move on to that now, if I may, and I'm going to try and do it quickly. But by way of summary, you will have seen from the record that on the facts as found by the judge and accepted, obviously, by the Court of Appeal, there was simply no other option available to EACL if it was to get any value from its investment in BEL. It wasn't, in the circumstances, therefore, an unusual transaction. You will have seen from the record, and this is the Statement of Facts and Issues, paragraph 21, at bundle 6, page 1822, that BEL was in danger, that is, the operating subsidiary, was in danger of losing its license in Indonesia. You'll recall that the BEL was effectually, its business comprised the development of a plant and then the production of energy from that plant for sale to the Indonesian government. There are 2 government contracts. And it's agreed in the Statement of Facts and Issues that the BEL was in danger of losing its license in Indonesia. You'll recall, that Justice of Appeal Clark in Bermuda, at paragraph 20 of his judgment, at bundle 1, page 51, found or accepted that BEL was in pressing need for funds, as indeed he said was EACL, both companies. He found at paragraph 21, at page 52 of Bundle 1, that both EACL and BEL were in danger of being struck off. And he found at paragraph 57, at page 63, that both companies were effectively broke. And he found, Mr. Howard's shaking his head. I'm just going to, unless it's for some other reason, I will go, if I may, to Bundle 1. Have I got it? Bundle 1, page 63. Paragraph 57, by the 13th of February 2015, PT Satria had completed its due diligence in respect of the purchase of BEL on the 16th of February 2015, by which time the time for responding to the cash calls, I'm going to come back to that, had expired. The closing negotiations began. By this time, BEL and EACL were, as the judge found, effectively broke. And then, my Lord, what the judge also found, or what is also accepted in the same to facts and issues at paragraph 23, is that cash calls made by BEL to EACL and by EACL to its sole shareholder AOL to meet immediate liabilities were not met. So what EACL says in its case, so we were rather surprised in light of those findings by the judge, and that's the same, agreed same to facts and issues, for that EACL says in its case at Bundle 6, page 1897, paragraph 43.2. Unlike BEL, EACL was not insolvent or on the verge of becoming insolvent. Mr. Justice Hellman found that BEL was in debt by almost $2 million and that it had no assets other than the JOC and the ESC, those are the two government contracts, which were in danger of being terminated. In contrast, there was no evidence that EACL, says Mr. Howard, had any significant liabilities or creditors other than its obligation to pay its annual fees to the Bermudan government. These annual fees came to just $2,500, and as at the date of the HOA, they were not, in fact, due to be paid until the 31st of January. In fact, they were due to be paid in advance, but that's a very minor point. So. Yes, that should be. Sorry, that should be. Mr. Gilliam points out that should be a reference to 2015, I think. So what we say is that EACL was plainly insolvent. As the Court of Appeal.
Well, paragraph 93, the Court of Appeal said it was not insolvent and had no significant liabilities. It's actually set out in terms there.
Paragraph 83.
Paragraph 93, saying that EACL was not insolvent and had no sizable liabilities.
Well, on the one hand it was, and on the other hand it wasn't. So it would seem to be. But interestingly, where's their case? Where's their case? Sorry? Sorry, I'm just looking very... Done? Could I invite my lords and my ladies' attention to bundle 1. And could I invite you in particular to the amended notice of appeal. This was EACL's amended notice of appeal to the Court of Appeal at page 33. There's the start of that 33. This is bundle 1, my lord. Yes, page 33. This is EACL's amended notice of appeal. And it sets out where the learned judge apparently got it wrong in 7 sub-paras, and then particulars of facts. Did personnel engaged on behalf of the respondent conducted detailed and technical due diligence, BEL, following renewal of the discussions, then over on to D, review of the register of directors of BEL and EACL. And then, this is said to be which included, the respondent conducted further due diligence, which included, E, a clear understanding on the part of the respondent, that's PT Satria, in February 2015, that both BEL and EACL had substantial commercial obligations and the two companies were clearly insolvent. That is EACL's case to the Court of Appeal. That was the case they were making. And that is repeated in paragraph 3 on page 36. Prior to the execution of the HOA, February 2015, the respondent knew that both Mr. Jones and Mr. Harter had an interest in the proposed transaction, an interest in the proposed agreement, given that they were assured payment of amounts set out above, which would otherwise be irrecoverable, given the insolvent status of BEL and EA, that should be CL. So the case that was put to the Court of Appeal was that both companies were clearly insolvent. So I'm not quite sure how the judge got to the position in which he found himself. But I will come on to look at the companies individually, if I may, and very quickly. The court is aware, this court is aware that the EACL had no assets other than its shares in BEL, which was its wholly owned subsidiary, and the only business of BEL was the project with those two government contracts. So it's clear, we submit, it's clear that the value and revenue prospects of BEL are dependent upon constructing and developing the power plant and the sale of electricity generated by that plant. And we say it's clear, it's obvious that EACL's sole business being the holding of shares in BEL, the value and revenue prospects of EACL are similarly dependent upon the value of BEL and any dividends paid by BEL to EACL. So that was the only source of income of EACL, upon the plant being developed and energy being generated. And that, in fact, is borne out by the PwC report dated the 12th of February 2010 on BEL's financial statements. I'm afraid they're only the financial statements for 2007-2008, because that is the latest one. And you will see the report in the statement, or the relevant, a reference to it in the statement of facts and issues, which is in bundle 6 at page 1822. It's 6, if you want mine. 6. At 1822. What is an agreed fact is 21, is that by late 2008 BEL was in financial difficulty. Its financial statements for the year ended 31/12/08, prepared by PwC, stated in note 15 that, going concern, as at the 31st of December 2008, the company has a negative working capital of 8.3 million, accumulated deficit of 11.9 million, recurring losses and negative operating cash flows Furthermore, the project is suspended as a result of delay in obtaining permit from the government. These conditions raise substantial doubt about the company's ability to continue as a going concern, since ultimate realisation of the company's assets depends on the successful development of its commercial production and continuing financial support of its affiliated companies and or its shareholders. That is on BEL, that is fair to say. So there's a doubt even then, and actually when the report on those accounts, financial statements, was made in 2010, there's doubt about the going concern basis upon which they could be prepared, having regard to the underlying business of BEL. The position of EACL, and if I may invite my lords and my ladies' attention to the Court of Appeal judgment in Bundle 1, and I'm going to, at page 50, paragraph 51, at page 52 of Bundle 1. I'm sorry, yes, the paragraph is 51. No, it isn't, is it? It's 21, sorry. My typing is not up to much. It's 21. On page 52, in addition, BEL and EACL had to pay their Bermuda government annual fees by the 31st of January 2015. Non-payment would incur the risk that the companies, plural, would be struck off the register of companies. Further, both companies needed to secure the services of a new corporate secretary to replace the old one, which had resigned, and to pay the new secretary's annual fee, which would be required in advance as an annual retainer. And these, we submit, therefore, are unavoidable liabilities of EACL. And then, if I may invite your attention to Bundle 5, to one of the cash calls made by EACL to AOL. It's at page 1577. And this is sent to AOL, East Asia. This is the one date. It's a very poor reproduction of the. I hope you're able to read this. What we see from this, East Asia wishes to advise that it intends to pay its Bermuda annual fee on or before the 30th of January 2015. As EAC doesn't have a secretary, notice from the Bermuda Monetary Authority has not reached the company, etc. He sets out what the fees are. He says, halfway down the page, literally, due to the deadline, do you see the, I hope my lords and my ladies see that. Due to the deadline of the 31st of January, in the middle of the page, set by the Bermuda Companies Act, the company would like your approval of the AFE as soon as possible. These costs cannot be negotiated with the Bermuda Monetary Authority. And you see they, towards the bottom of the page, just before the last paragraph, they're asking for almost $2,500. This letter shall serve as an invoice or cash call to Affluent Ocean Limited. That is the sole shareholder of EACL for its 99.9% share of the Bermuda annual fee. And then he says about when the money needs to be handed over. So that was a cash call, and that's one of a number of cash calls. But they were, he does also say it's not negotiable again, in the penultimate line of that paragraph. So that is one of the number of cash calls made to AOL to pay even a sum of $2,500 on that case. Yet, as the judge found, and as the Court of Appeal accepted, and as is stated in the agreed statement of facts and issues, all of the cash calls went unanswered. what is said in the Statement of Facts and Issues at page 1822, at paragraph 23, is that by the end of 2014, no suitable investment partner and/or buyer had been found for BEL. BEL had a pressing need to find funding. In December 2014, BEL issued cash calls to its shareholder, which in turn issued cash calls to its shareholder AOL, but these cash calls went unanswered. And as the judge in the Court of Appeal pointed out, they were at risk of being struck off if they didn't pay their fees. Now, of course, as we know, my lords and my lady, EACL had no income from which to pay those fees. It had no other separate business. No dividend could be paid up to it by BEL. And the only other source to enable EACL being struck off was a cash contribution in some form from AOL. But that wasn't met. So you've got a situation in which BEL can't develop the project, it can't build the plant, which prevents it selling energy, because it can't produce energy and therefore none can be sold pursuant to the government contract. So BEL has no income. BEL is the sole asset of EACL. EACL has no other business. It's entirely reliant on monies coming either from below, i.e. BEL, which are unavailable, or on money coming from above. That is to say the cash calls. But no source of income was available to EACL. And it's in that circumstance, so we'll see, perhaps we can see, have you got some? Where's the button? If you would just please bear with me for a minute. Yes. You will recall from the judge's judgment at, what is this, 1437. You'll recall from the judge's judgment that when negotiations took place, and it's accepted in the Statement of Facts and Issues, that negotiations were entered into 2011-2012 with PT Satria. They came to nothing. Then there were two MOUs entered into with a company known as PBS. And, my lord, one of those MOUs, the second one of those MOUs, is in bundle 5 at page 1438. And what you see is that this was an MOU for the potential sale to PBS by AOL, that is Affluent Ocean, of EACL, i.e. the holding company. And what you just, if I may just a number of unusual features. There's some, well, they're not unusual in the context of what this company was trying to do, because even with this MOU, you will see in paragraph 2 at page 1439, the price payable was a full $8,000 US. But you'll see in paragraph 3 that effective from the closing upon the second party, and the second party is PBS, legally owns the sale shares until the commercial operation date of the plant in accordance with the energy sales contract. The first party, this is halfway down this clause 3, the first party, that is AOL, shall not be required to provide BEL with any loan or cash contribution, and to prevent dilution of the participation of the first party in BEL, if the first party is required to make any capital or operating expenditures contribution, the second party, that is PBS, will make such contribution on behalf of the first party. And then if you go over to clause 12 on 1440, you see you see here in paragraph 12, and this actually is a binding obligation. You see that from page 1441. The paragraph which deals with is immediately after 17, other than matters addressed in paras 9, 10 and 12, which the first party and second party agree shall be legally binding on the first and second party. So this is a binding provision that immediately upon the confirmation of the signing of the MOU, the second party agrees to pay all outstanding salaries owed to the employees of BEL, including severance, all outstanding salaries owed to the executive of BEL, taxes, Indonesia Tax Authority, legal fees, and so on and so forth. So that's the sort of transaction that the owner of EACL was prepared to enter into. And if you go forward in that same bundle to page 1437, you just see the scale of the list of outstanding liabilities of BEL.
Sorry, which page?
1437, 1437, so going forward in the... And you'll see the liabilities at the 1st of December 2013. And these, and you see the quantum of these. You'll see that back pay, and you divide these by 12, don't you? You divide the Indonesian rupiah by 12 and you get a US dollar equivalent. But you will see there's a very substantial, so Indonesian rupiah 24 billion divided by 12, you've got $2 billion outstanding liabilities. You can see the date, so you see some tax liabilities, some rent liabilities, and you see some liabilities going back to, for staff, going back to April 2013, and so on. So BEL is plainly insolvent, unable to pay anything. AOL was prepared to enter into a sale of EACL for $8,000 with a top-up if the plant achieves some super wattage output, and that is dealt with in paragraph 5 of the MOU. But unfortunately, that MOU, good as it was for AOL, because it at least gave it $8,000 US with a potential to earn some more money, that was cancelled. It's never proceeded with, so we're told by the court. And that it was cancelled in October 2014 is clear, I hope, from Bundle 1, page 51, at paragraph 20. Yes, page 51, PBS cancelled the second MOU in October 2014. This left BEL with a pressing need to find alternative funding. The minutes of a board meeting of BEL, which took place on 14th December via Skype, and which the directors present were Mr. Jones and Mr. Harter, noted that whereas the key assets of the company, namely the JOC and ESC, were intact, there's a possibility that due to financial constraints, the company would fall out of compliance with them. Where is this? Can you show me the accounts of BEL? There's financial statements. What if my lords and my lady have bundle 5 still to hand, at page 131397 are those earlier financial statements from the reports upon which I read a moment ago from the statement of facts and issues. You will see on page 1401 the balance sheet of Bali Energy Limited. And you'll see there, as at this date, in 2007, as reported in 2010, actually accumulated losses of $11 million in 2008. You actually have share capital and total shareholders' equity of 25 million, but that is matched entirely by the power plant under development. See that under non-current assets. So if you don't have that, plant under development and able to value it at 25 million, you haven't got anything left. And what we say what we submit to the court is that in those circumstances, it cannot properly be said, as my friends have sought to characterise it, that that perhaps I can just take it. Where does it say it's unreal? Where does he say it's unreal? It cannot properly be said, in our respectful submission, that this was a transaction of an unusual nature. As we submitted to my lords and my lady, this was the only prospect which EACL, of deriving any benefit whatsoever from its assets, was this sale. Even if most of the value of it was to come from the hope value that it could, the plant would produce a super degree of wattage for sale. If you got it, sorry, and that takes me on to I think the final point which I would wish to deal with, if I may, and I'll do it quickly.
Yes, well, if you can deal with it as briefly as may be, that would be very helpful.
My Lord, I can deal with it very briefly, and it is simply this. I'm going to refer you, if I may, to... This is the factor said by the Court of Appeal to militate against the existence of a sensible authority. And it's that which the Court of Appeal set out at paragraph 110, at bundle 1, pages 86 to 88. I have drawn my lords and my ladies' attention to the fact that we answered each of those points in our written case. And those are in paragraphs 15 to 18 at bundle 6, at page 1852. And I wasn't going to add to those. I can read them to you now if you would like me to, but we have...
You can take it. We've already read them, and we'll no doubt look at them again.
I'm grateful. I wasn't doubting that you had looked at them. The other thing is in 1.3, yes. The point I was looking for about the sale of the assets, the sale of the BEL as being a normal transaction. What my friend says in paragraph, he says in bundle 6, page 1887, at subparagraph 7 of paragraph 19, he says PT Satria accepts in its written case that in determining whether an agent had a sensible authority, it is necessary to assess the nature of the transaction in question, and that the more unusual the transaction, the more unreasonable it may be for the third party to rely on any ostensible authority. However, its suggestion that there was nothing unusual about the HOA and its attempt to present it as a mere fundraising or as a sale of assets is, with respect, unreal. We say in the circumstances. That's not correct. There's just one other thing I would take my lords to, and my lady. It's the Court of Appeal judgment in bundle 1. It's page 96. It's paragraph 136. Oh, no, it's not. Sorry, 132. Sorry, it's page 96. I'm looking at page 90. Page 96, paragraph, could I invite you, please, to look at paragraph 132, the matters upon which the appellant relies to defeat the claim to rely on a sensible authority can be summarised as follows. And in relation, PT Satria and Mr. Sedano knew that only the board had authority under bylaw 45 to authorise the contract, and individual directors such as Jonas could not acquire such authority unless it was delegated to him. We say in relation to that, you've had my point, Mr. Sedano knew that 2 out of 3 directors were approving this transaction. And then in relation to B, we say that, well, that is correct, but it doesn't take the matter very much further forward. We say in relation to C, that is financial due diligence, Turquand. In relation to D, PT Satria knew that Mr. Jones and Mr. Harter required the approval of EACL for the HOA as clause 6 of the HOA confirmed. Firstly, that isn't what clause 6 says, but I'm not going to trouble you particularly with that. And we say it doesn't take it doesn't matter in any event because of a Turquand. And then in relation to the matter set at E.
But just on D for a moment, could I just ask you for a little help on the evidence, because I've not read it all, I'm sorry to say. Is there some reason why the transfer wasn't executed on the 27th of February? Did everyone realise there was going to be the board meeting on the 1st of March, and did the transfer therefore follow the board meeting?
My lady, I cannot tell you the answer to that, because I don't know. I will just check.
My question was what the evidence said.
Yes,
there must be something to explain why there was that.
My lady, can I ask those who are around me to try and search out the answer to that, if there is some evidence, and we'll just let you know what it is during the course of tomorrow. I won't make submissions on it. I'll just tell you where the evidence is, if there is such.
We might have a question.
Well, I'm sure you might. I'm getting used to that.
If we could have it in the morning.
No, of course, my lady. And then in relation to E.
E and F were not accepted by the Court of Appeal, were they?
No.
If you look at 136, I understood, and I'd just like to check with you, line 5,
yes.
reference to 118 should be to 132.
That's correct.
And subparagraphs E and F
were not accepted.
How it tells us otherwise, we can ignore.
That's quite right. They relied, the Court of Appeal apparently in Bermuda does not work on Sundays, that's letter G. Well, I dare say in Indonesia they might well be working on Sundays. And in H, we say that doesn't take the matter any further forward. And in relation to I, we say it doesn't take the matter very much further forward. The urgency was because of the potential to lose the licence. My lords, unless I in relation to the remaining issues, 4, 5, 6 and 7, I don't add anything to the written case which we've got. Unless I can assist you further, I'll sit down gratefully.
That's very helpful. Thank you very much. And Mr. Gillian, do you follow? Mr. Howard.
My Lords, the shares in EACL are owned by AOL, a company entirely owned by Mr. Watabe. EACL is the sole shareholder in BEL, which is its only asset. And as Justice of Appeal Clark observed, EACL had no other assets than its shares in BEL and was a holding company for Mr. Watabe. Mr. Jones and Mr. Hatter were directors of both BEL and of EACL, but they were not the only directors. By the end of 2014, BEL, although enjoying a potentially valuable right to develop a geothermal energy unit site in Bali, was cash flow insolvent. Now, what is important, and Mr. Todd has entirely skated over this, is by the spring of 2014, there were disagreements between the Watabe camp on the one hand, and of course the Watabe camp were the owners of EACL, and Mr. Jones and Mr. Hatter on the other. Indeed, the writing was plainly on the wall for Mr. Jones and Mr. Hatter, because various steps had been taken to remove them as directors, including the convening of SGMs for that purpose, which they were seeking to avoid on technicalities. can I remind you, in the Court of Appeal's judgment, where this is all set out, at paragraph 44, I'm not going to read it out, if I can just remind you of where they set it out. Paragraph 44 shows that this started in January 2015, and then 48, and then if you see 49 was an SGM that was summoned for the 9th of February, and at 52, somewhat remarkably, Mr. Hatter and Mr. Jones sought to say that this was invalid, the way in which the meeting had been called. And if one thinks about that for a moment, these are two employees who have no interest at all, other than, of course, getting paid the fees that were due to them from BEL. So they, at this time, are secretly, apparently, negotiating with Mr. Sahardono, whilst knowing that they're about to be removed. And then if you go, they having taken this technical point, paragraphs 54 and 55, and this is, Mr. Todd sought to explain to you why things were happening on the Sunday, saying, oh, it's because the license was about to be removed. That's not the case. It's because of what you see at 54 and 55. Jones and Hatter, on the 4th of March, the guillotine was coming down. That was the urgency from their perspective of this, that come the 4th of March, they would not be able to do this. Now, what is very odd about this case, I'm going to take you to the HOA in a moment, but as the Court of Appeal has observed, there's not a single document recording any communications with PT Satria about this. The first document that appears is the HOA. Now, that is at 5, and I know you've all looked at it, 5/16/19. If I could just ask you to turn it up. Or the actual executed copy is at 16/22, but a more legible version is at 16/19. Now, the important things to note about this is, firstly, this is an extremely flimsy document, which is the basis for selling off this asset. Now, at first instance in the Court of Appeal, there were issues as to whether or not it was capable of being a binding agreement, but that's all now water under the bridge. What you see at paragraph 2 is a EACL purporting to sell 100% of its shares to a competent investor that would develop and operate the project. And PT Satria seeks to purchase with a commitment to developing the geothermal project expeditiously. Now, of course, what you would expect in any proper agreement is this all to be spelt out as to what exactly their obligations were. And the reason that matters is that the money that was to be paid to EACL was entirely dependent upon, as you see at 3B, the commissioning of the final unit of the project. And so unless you had terms which spelt out very clearly what they were required to do, the prospect of EACL getting paid or paid any time soon was somewhat remote. Now, the two directors receive their remuneration through 1621. And what you find in 1621 is that immediately the shares are purchased, the acquirer was to pay, amongst other things, you can see it comes to $518, about $500,000, to the two directors, and that is in the middle of the page. Half was within 2 weeks of the transfer of shares, that's the 241,500, and then in the next block, within 1 month, 25% and then another 25% within 2 months. In addition, the sum which is in respect of a lease payment was to the benefit of these directors. Now, not only were they to get paid, they were in fact getting paid on better terms than most of the other creditors. Now, the other odd thing about this agreement is paragraph 6 and paragraph 7. You see, in paragraph 6, purported guarantee being given by Hatter and Jones that all approvals needed to sign the HOA have been obtained. And then in 7, Hatter and Jones, jointly and severally, undertaken to indemnify and keep indemnified and hold harmless the purchaser from any claims, etc., as a result of or in connection with any breach of any representation, warranties, or covenants. And that includes the warranties that they gave as to authority. Now, you can see it was purportedly executed by Mr. Jones on behalf of EACL, witnessed by Mr. Hatter on behalf of BEL. Now, the Court of Appeal has found, and this isn't in dispute, that no other directors of BEL or EACL or AOL or Mr. Watabe were aware of any of this. That's paragraph 27 of Justice of Appeal Clark. So this was on the Friday. The next thing that happens was 2 days later, on the Sunday, was board meetings of the two companies, at which only Mr. Jones and Mr. Hatter were present. Now, the minutes of the board meetings are in volume 5 at pages 1634 and 1636. And these minutes were never seen by the claimant, but by P.T. Satria. They weren't seen at any relevant time. Now, as I say, the reason for the urgency in the matter was fairly clearly because Jones and Hatter were about to be removed. Now, the Court of Appeal found that in relation to this meeting that Hatter and Jones had a conflict of interest and an interest which they were bound to declare. In the absence of a declaration, and that is a matter that had to be properly declared at the board meeting, the board meeting was inquorate and without effect. In other words, the effect of that was there was no board meeting.
Vis-à-vis the company. Vis-à-vis the company.
Vis-à-vis the company, but my lady, that is actually vis-à-vis anybody, because no one else saw this. It's not a case, as I said earlier this morning, where P.T. Satria is saying, well, I saw this board meeting and I relied on it in some way, therefore I'm entitled to assume it was properly conducted. The issue of ratification is entirely, as it were, an internal question. Was there a board meeting, a properly constituted board meeting, at which the directors did ratify? The answer to that is yes or no. If it's no, it's not, the rule in Turquin doesn't come into it in this case. And that's why you don't see that as part of that discussion if you look at the relevant part, as we will in a moment, of the Court of Appeal. Now, that is why, as I said earlier today, the grounds of appeal didn't go into the ratification issue. And indeed, in his oral submissions, other than the toing and froing we had at 10:30 this morning, Mr. Todd didn't actually address ratification. And indeed, in our submission, the only issue properly before you is the one of ostensible authority in relation to the entering into of the HOA. Now, my Lord, against that background, our position, EACL's position, is it's not bound by the HOA. Firstly, it's common ground that Mr. Jones did not have actual authority to enter into the HOA. Secondly, and this is the critical point for the appeal, EACL did not hold out Mr. Jones as having ostensible authority to do that. There was no representation to that effect, and that's actually critical. There no representation, there was no pleading of a representation, there was no pleading of any reliance, and what's more, as a matter of fact, there was no reliance on any alleged representation. And I will have to show you the evidence very briefly, which is actually unequivocal about that. The witness didn't purport to say, I understood that Mr. Jones had authority because of some holding out. What he says is, oh, I knew him from something else I'd done with him 10 years ago or so, and I trusted him. Yeah. Now, the reason I stress that, and it's important, is that being so, you never get to the issue that Mr. Todd spent a lot of time on, which was the Akai case. And you will have seen in his written case seemed, and certainly the way we read it, seemed to accept that the way matters were put in Akai was actually not the correct test. But anyway, he's developed that. But leaving aside the point that there was no representation and no reliance in fact, we say, and that's what the Court of Appeal said, was in any event, P.T. Satria was put on inquiry as to the lack of authority. Can I just remind you, by looking at the Court of Appeal judgment, how the matter there arose? If you go to, just so one can see the architecture of it, if you go to paragraph 88 of the Court of Appeal, from 88 onwards, the Court of Appeal, 88 to 98, the Court of Appeal was dealing with conflict of interest, which leads to 98, where the Court of Appeal explains, at 97 and 98, why the EACL board meeting was inquirate. Then at 99 to 101, they're dealing with the BEL board meeting. That's probably sort of icing on the cake because it doesn't really matter. It's all about EACL. Then you'll see at so that, as it were, dealt with any argument based on ratification. The court then, at 102 onwards, is dealing with the ostensible authority case. And the first point that the court was getting out of the way at 102 to 105 is why you couldn't rely on the rule in Turquin's case to assist because, and they quote from Houghton at 103, the reason for that was you couldn't use the rule in Turquin's case to create ostensible authority. And that's the simple point. So you can't say, well, I've assumed that somebody's had a power delegated to them and therefore they have authority. You have to point to something, some act of the company in holding out. And so then, having disposed of that point, and I'll have to show you how it was dealt with below, why they dealt with it like that, then at 106, they deal with holding out. And under that heading, you'll see at 106, as you would expect, Justice of Appeal Clark correctly sets out the relevant tests that we have in an ostensible authority case, which is, 1, is there a representation? 2, was it made by somebody with actual authority? And 3, was there reliance? And what he then is doing in this section, which goes through to 1 to 5. Oh, no, sorry, I beg your pardon. Which goes through to the end of 1110. Justice of Appeal Clerk is finding both that there was no representation and no relevant reliance. That's why, as a matter of fact, the ostensible authority case is doomed. He then is dealing with a case at 1111 through to 125 with a case which has been abandoned. That case was that this slightly odd idea that Mr. Jones could have had authority to represent that he had authority. It's a controversial point. I'm sure you're all familiar with Kelly and Fraser and the other cases, but it's not being run anymore. And so that's what he was dealing with there. So that's not a point we have to worry about. Then he dealt with put on inquiry just after 125. And this is, you can see the way he introduces it. The appellant submits that P.T. Satria was in any event put on inquiry, which it failed to make, etc.
So sorry,
yes.
Which paragraph were you on for the on inquiry?
It starts at 126. The heading put on inquiry is at the foot of the page after 125. But the point is, he's already found there's no ostensible authority because there was no representation and no reliance. Here he's considering a further submission that was being made by our side, which was in any event, P.T. Satria was put on inquiry. So this only arises, this area of debate, if one said there was a representation which in fact they did rely on, and then the question is, well, were they entitled to rely on it? That's how it's arisen. Now, what in fact Justice of Appeal Clerk did was he actually said he was bound to, he ought to follow Akai. And the reason he said that is if you look at 131, is that he recognized at 130 that Akai was controversial, according to Balstead, but he says at 131, he says the points made by the authors are substantial, they weren't developed in detail before us. I'm prepared to assume that the decision of the Final Court of Appeal of Hong Kong was correct, not least because any decision on this question would be obiter. In other words, this point doesn't actually matter because he's already found that there was no relevant representation and no relevant reliance. And so what the Court of Appeal was saying is if this point arose, they would have followed Akai, and the result of that was, you see at 136, that if you adopt the test in Akai, and if he'd concluded that Jones had ostensible authority, which he didn't, then he would not have concluded that Satria was disentitled to rely on it. But if the test is, was Satria put on inquiry, then he would accept they were. So you can see this point only arises in the event that my learned friend's able to establish both a representation and reliance. Now, we say, in fact, when one's looking at reliance, as my Lord Carnwath was saying, essentially, you can't, in this area, say I'm relying on a representation unless your reliance was reasonable. If it was unreasonable, then you fail. And it doesn't and that's part of the criticism that Balstead make. It's not, this isn't some separate species of law relating to companies or anything of that sort.
So this is a sort of respondent's notice point, I suppose, in this jurisdiction. I'm not sure whether one has formally respondent's notices, but you're saying, I mean, the judge was, on this point, prepared to follow Akai. You say, in fact, Akai, it does not contain an accurate statement of the law. On an accurate statement of the law, this is yet a further reason why exactly the appeal should be decided.
But in fact, one never got to this because the Court of Appeal had found in our favour on the prior points. And so this is all...
That's what I meant by respondent's notice point. It's an additional reason why you should have won, additional to the reasons for which you did
exactly.
alone.
But which we don't need because we won on the other points. Now, The next point, just in the architecture of the case, is the Court of Appeal, as you've seen, took the question of ratification first. And there's a logic to that, obviously, because if one said the 1st of March, this was a valid board meeting which ratified the HOA, then questions about ostensible authority and reliance all become moot, as does the question of avoidance. But in chronological sequence that comes next, and the Court of Appeal found there was no ratification. Now, and it's important for me just to restate that there is no appeal against the finding that there was a conflict of interest. That's not part of the appeal. Secondly, the issue about ratification wasn't part of the appeal or the statements of fact, save insofar as reference to effectively a legal question as to whether non-disclosure could have prevented the board being inquirate, and we haven't heard anything to explain why the legal consequence does not follow. Now, as I've already said, the rule in Turquand has no relevance to this question. It's simply a question, did the board in fact ratify? Now, assume there wasn't ratification, a further issue arises, which is, or could arise, but only if you were against me on ostensible authority, which is this, and which is, if the HOA was otherwise enforceable because Mr. Jones is to be treated as having authority, it was voidable and has been avoided. The Court of Appeal dealt with that after, yes, they deal with that. That's what they're dealing with at 137 to 139. So that's under the heading of voidability on account of the failure of Jones to declare an interest in the HOA. But as Lord Justice of Appeal Clark states at 137, this is all again obiter, because it only arises if Jones had ostensible authority. And then you have to consider whether the HOA was voidable. And that's where the put on inquiry test what comes in relation to a different point. But the simple point there is that Mr. Jones and Mr. Hatter had a financial interest in the sale. They didn't disclose it. The effect of that was that the transaction, if it was otherwise binding, was one that was entitled to be avoided against a party who was put on inquiry. Now, my lords, with that introduction, if I turn to the question of ostensible authority, now that raises two issues. One, was there a representation, a relevant representation? It's got to be a representation that Mr. Jones had authority to enter into the HOA. That's the representation you're looking for. Secondly, did PT Satria, Mr. Suhardno, did they rely on that representation? Now, as I said, it's not in dispute that Mr. Jones did not have actual authority, and that's because, pursuant to bylaws 45 and 46, only the board of EACL had the relevant authority, and the board hadn't delegated any of its powers to Mr. Jones. Now, Mr. Suhardno, as you'll see, was fully aware of Articles 45 and 46. He specifically draws attention to them in his witness statement. Now, as with any representation of giving rise to authority or an estoppel, what you're looking for is something which is clear and unequivocal. Now, the difficulty in this case, which has not been adverted to by Mr. Todd, is that his client did not plead a case of ostensible authority. So they didn't plead a case as to what the representation was or as to who relied on it and in what respect. And that's at paragraph 112 of the Court of Appeal's judgment. Second sentence, there was nothing on the pleadings about ostensible authority or reliance on any representation, express or implied, as opposed to a non-admission that Hatter and Jones lacked proper authority. Now, this isn't, as it were, just a technical pleading point. It's a point that goes to the very heart of what it is that's being said, because one needed to know exactly what the representation was, how it was made, and to whom, and who of P.T. Satria was supposed to have relied on it. Now, if you go to, well, before I go to the, yes, perhaps we could go to the first instance judge to see what he said about this, and you'll see where things go wrong. And that is in bundle 1, page 1. And if you go to paragraph 62, you can see the learned judge there says, in any case, applying the indoor management rule, otherwise known as Turquin's, Satria was entitled to assume that as directors of EACL, Jones and Hatter were authorised to enter into the HOA on EACL's behalf, even if, contrary to my findings, they were not. The so-called rule in Turquin's case is, I think, correctly stated in Hallsbury. Persons contracting with a company and dealing with it in good faith may assume that acts within its constitution and powers have been properly and duly performed, and are not bound to inquire whether the acts of internal management have been regular. Thus, as between the company and outsiders, outsiders are entitled to assume that its directors act with the authority of the company which will be bound by their acts. That's unless the outsiders know or have noticed that they're not so authorised. Now, just stopping there for a moment, that was a misstatement of the law, and you can pick up what the correct position is, and I haven't heard anything to suggest that this is controversial, in the Court of Appeal's judgment at paragraph 103. And at 102, he quoted, referred to what the judge had done, and his quotation from authority. And at 103, the Court of Appeal said that, in my judgment, the rule, whilst covering procedural irregularities, such as a failure to have a loan passed by the relevant board committee, does not extend to entitle a third party automatically to assume that where the bylaw allows a delegation, such a delegation has taken place. And he refers to Houghton, and he sets out the well-known passage there, and you can, well, I'm sure you're familiar with it, and I don't need to read it out. But that is absolutely, as it were, hornbook stuff, that merely because a company has the power to delegate, the rule in Turquin's doesn't allow you to assume that has been done. And as at 105, he quotes from Akai, and it's actually the Northside Developments case, which Lord Neuberger was quoting from, which is what which Justice of Appeal Clark was setting out. But essentially, in this area, you've got to independently show some representation by the company, and that the rule in Turquins can't be used to create the ostensible authority. So that's where the judge first went wrong. He was starting from the premise that you could assume that delegation had taken place. And if I could take you back to the judge then at 64, the first instance judge, he then said, in the present case, PT Satria had positive reasons to, it's volume 1, tab 1, PT Satria had positive reason to believe that Jones and Hatter were authorised. And if we look at what he's relying on, its staff spoke with Jones and Hatter. So just stopping there for a moment, that would be them self-authorising. Reviewed the corporate documents, well, of course, they didn't establish it. It established to its satisfaction that Jones and Hatter remained directors. Well, that was true. The board had authority to enter into an agreement, or the board as a whole did, and that the board had authority to register the share transfer. It also established with the various Indonesian state authorities that Jones was their key contact in all matters. In other words, there is no finding by the judge of any relevant representation by the company, nor of any relevant reliance. So, and his conclusion at 65 simply did not follow from what he had set out. Now,
I mean, how did the judge get into the ostensible authority aspect of it having been needed? Was it raised in skeleton argument?
It was raised in a skeleton argument.
And the court accepted that it could be raised?
Yes. I mean, I don't understand there was actually a battle about it. So I'm, as it were, not saying it's not open. Obviously, I'm not saying that. But the effect of it not being pleaded is why you get into a muddle. You then have a judge in his judgment who simply has found ostensible authority on a basis which doesn't reflect any determination that there was a representation or relevant reliance.
But if it was raised in the skeleton argument, do we get a clearer understanding from the skeleton argument as to the way the case was being put?
Can I check overnight on that? But then... And what one sees, essentially, the judge was working on the basis that you could just use the rule in Turquin's case. That was actually clearly what was the critical part of his finding. Now, what is important, and I'd like to show you this evening, is the evidence on this. And if you would go to bundle 2, you'll see in our submission why a case on ostensible authority is simply a non-runner against the evidence. Now, volume 2, page 558, is Mr. Suhardono's witness statement. And I'd just like to pick out a couple of critical points, and then I want to show you what he said in cross-examination as to what he actually relied on. So, paragraph 9, firstly, he refers to, in the second sentence, so in paragraph 9, he's dealing with what happened in 2011, and he says in the second sentence, during early 2012, we conducted detailed commercial, legal, and technical due diligence on Bell. This included examining both companies, BL and EACL's company documents and bylaws. And then, if you go to paragraph 11, which is then moving on to the due diligence that they did in 2015, the fourth line, he says, we concentrated on updating financial and legal due diligence. And then he says, we confirmed with Hatter and Jones that they remained as directors of EACL and BEL, and that, according to the bylaws of the company, they were in a position to effect a share transfer. We looked at the bylaws, at the register of members and directors. This work was carried out by my staff who reported their findings. we were satisfied on inspection of these documents and the assurances of the two directors that the board of EACL had the authority to transact the business and to enter into an agreement with us for the purchase of its interest in BEL, and that the board had the authority to register the share transfer. And he then refers to Articles 45 and 46. In other words, he is saying, I was aware of the company documents and I understood that this was a matter for the board. He then says, having referred to the various bylaws, the Register of Directors and Officers confirmed that Hatter and Jones were current directors. Hatter and Jones told us that they had authority, and we had no reason to doubt their statements. We had, after all, been dealing with them since 2011, and it had been the consistent conduct of EACL to find an investor or purchaser. Now, just stopping there for a moment, the fact that you may charge somebody with the duty of going out to find a purchaser doesn't mean that that person has authority to contract on your behalf. And I'll show you authority that says that, but that's indeed a matter really of obvious common commercial sense. Then, interestingly, he says, I was aware that Mr. Jones and Mr. Hatter dealt closely with the operations of both companies, while a Japanese individual called Watabe had purported to act on behalf of AOL. I understood from Hatter and Jones he was not a registered shareholder or director, nor had a power of attorney. Now, we'll see elsewhere. What he did know was that Mr. Watabe was the ultimate beneficial owner of EACL through AOL. Now, if you then go on to paragraph 13, he makes the point
He doesn't seem to mention Mr. Yamura.
No, he doesn't.
It doesn't tell us what was in the Register of Directors and Officers.
I think you'll see in his cross-examination he does, except that he knew there were other directors, I think. What you'll see is in paragraph 13, where he refers to the signing of the HOA. Here, all he's relying on, you can see in the way this witness statement was drafted, was that Jones and Hatter had told him. And then, if we go to 19, which is interesting before we look at the cross-examination, he says, the defendants have alleged in paragraph 3 of the defence that the plaintiff knew or ought to have known that Jones and Hatter were acting without proper authority and or in a conflict of interest. It's denied they were acting without authority, or if they were, the plaintiff had any knowledge. I can find no requirement within the bylaws that AOL's consent should have been obtained prior to the execution. But interestingly, what he then states, the bylaws firmly place the running of the company in the board's hands. Also, our negotiations were consistent with our earlier negotiations in 2011-12. We knew that the companies were in a poor financial state and were seeking a purchaser. In any event, and this is again interesting, Jones and Hatter provide us with a written assurance that all necessary approvals had been obtained. And then he says, from looking at the board minutes, I believe that the agreement and the transfer were both ratified as required by the boards. So in other words, he at all stages understood that this was something which did require the board approval. He's not in any way saying, well, I dealt with Mr. Jones and I just understood he was the person with authority to act. Then he goes on to make some point about why he says it wasn't a financial inducement to Jones and Hatter. Now, if you could turn on in this bundle to a relevant extract from the cross-examination, which I can take quickly before we break, start at page 641, if you would. And at the top of 641, which picks up Lady Arden's point, you see the question was, you knew that the directors of EACL were Hatta, Jones and Yamura, correct? And at line 13, he says yes to that. So when you were negotiating, you knew there were 3 directors. Line 20, yes. Did you ever have it, line 21, did you ever have any communication with Yamura? And that is at line 7 on the next page, no, never. Then in relation to Bell, perhaps similar questions at line 8 onwards about 8 to the bottom of the page, and top of page 526 or 643 in the bundle. He didn't deal with any of the other directors of Bell. And then if you go to at 643, line 21, why didn't you have any contact with the other 3, this is directors of Bell? Because I trust Mr. Edwin Jones. On what? What made you trust him? Okay, because in 1994 I used to work together with Mr. Edwin Jones. Yes, and that's why you trusted him. Yes. You knew that they were negotiating with you to sell the shares of Bell. Yes. And you knew that those shares were owned by EACL, its only asset. And he confirms that at line 18. And you knew that EACL was owned, apparently, or the owner was Mr. Watabe. Yes. Did you ever see a document authorizing Jones or Hatter to negotiate and sell the shares? No. So what made you think that either Jones or Hatter could sell the shares belonging to their company? Line 12, what made you think that either Jones or Hatter had the authority to sell the shares? Answer, 17, because I trust them. And then the question, no, that was the only reason you trusted them. Okay, I trust them. I trust them that they're not going to break the law. Well, you knew there were other directors other than them. Yes. You didn't try and contact any of those others. No. Any reason why not? First, I trust that Mr. Jones would not break the law. Secondly, second is what I have to take care of. It's a lot of stuff. Mr. Hussardado, and then he goes on to say this was a multi-million transaction. And at the foot of the page, you took no steps to make sure the people that were selling you, or saying they were selling you the shares, had the right to do that. And you get line 11 on the next page. No. Why not? Because I trust Jones. And that's the only reason you didn't check. Yes. So in our submission, the witness does not in any way say that I relied on any representation from EACL that Jones had authority. He, in fact, is saying, I always knew that this was a matter for the board, but I trusted Mr. Jones. I trusted him not to break the law. I knew him. Now, this has got nothing to do with a case on ostensible authority. In our submission, all that evidence means that this case on ostensible authority is completely hopeless.
So if directors of a company, are faced with a situation that the company is becoming insolvent and the position of the creditors is getting worse, what is their obligation if they cannot get authority from the board?
I'm sorry.
What is their obligation? What does their duty require them to do if they call a board meeting and they can't get a board meeting to resolve the situation?
Well, so doesn't go to the question of ostensible authority in relation to the HOA.
It's leading it on.
That goes to the question of whether the board meeting was a proper board meeting. Well, in our submission, I mean, if one looks at what's happening here, you've got BEL, which has got significant liabilities, and they are directors of BEL. But their duties we're concerned with were as directors of EACL. And it's perfectly clear that EACL doesn't have any significant liabilities. There's no evidence that it had any other liabilities other than to pay $2,000 in respect of company dues. Now, in response to your lady's question, what should a director do in that situation? In our submission, I think you saw the requisition of the board meeting, or if you haven't, you've been referred to it. And that is all in very, very general terms. What a a director acting properly would do would be to put on notice that, firstly, there is a transaction where the principal asset is to be sold, and secondly, explaining that they stand to gain $500,000 and that EACL stands to gain potentially nothing, or if it is to gain anything, it's in the long distant future on a very contingent basis. In other words, you have to make disclosure.
Yes, that says nothing about their duties to the creditors. Anyway,
the creditors of which company, though, my lady? The creditors, there's a danger of confusing the two different situations. BEL had creditors, significant creditors. EACL did not. Mm-hmm. And so and indeed they weren't doing anything to raise money the only creditors we know about are the $2,500 to the as fees for maintaining the company on the register. They weren't even getting paid that. So they can't say, well, we were in a desperate plight and EACL would be struck off, and so we got a couple of $1,000s in order to avoid that. The only monies they got were monies that were for BEL. Now, so...
Sorry, just on that, I thought that was actually the significance of paragraph 93 in the Court of Appeal judgment. You remember we had some debate about whether EACL was insolvent and so on, and you drew our attention in the course of that to paragraph 93, which is on page 77.
Yeah.
And I rather thought that was why Justice of Appeal Clark was making the point there, EACL not insolvent and no sizable liabilities. In other words, the director's duties remain to the shareholders.
Exactly.
We hadn't reached the point where they flip and they're owed to the creditors.
That is the point he's making, that this wasn't a situation where EACL's creditors' interests took precedence because it didn't have any significant creditors. Indeed, the only evidence of creditors was the need to pay fees to keep it in being, and obviously that has been done because it is still in being. And so what Mr. Justice of Appeal Clark was saying here is what you had to consider in relation to this conflict of interest point was their position as directors of EACL. And that's where they put their own interests ahead of EACL's interests. That's what he's saying in 93.
Yes, is that a convenient moment, Mr.
Yes, I was just wondering. I'm happy to carry on, but I'm equally happy to stop.
Have you got the answer?
Yes, absolutely.
Well, I think that is a convenient moment. Thank you very much. We'll meet again tomorrow morning.